Domestic violence restraining orders. What are they? What kind of an effect can it have on your divorce proceedings? What you should do if you feel unsafe living in your own home? And what kind of evidence is needed to increase your chance in getting that restraining order granted? In this video, we're covering it all. Hi, I'm Mohajer. I'm a family law attorney practicing in the greater Los Angeles County since 2012. I've been a contributing member of the Los Angeles County Bar Association, and I've been rated by Super Lawyer since 2019. A domestic violence restraining order is designed to add a level of protection for the person needing protection. For example, if you're being abused by someone you live with, that you're in a relationship with, you share a child with, whether they've harassed you, stalked you, impersonated you, this type of proceeding is designed to give that level of protection to ensure that the other person cannot come within 100 yards to you, your vehicle, some of the children that you might need protection as well with, your school or place of business. Now, the type of effect that it could have on your divorce proceeding, it really depends on the root of what California law states about fault and no-fault divorce. You have to remember, California is a no-fault divorce state. So that means no matter what the situation was that stemmed to the divorce, you can't gain an advantage and, for example, get the house outright or increase in spousal support as a form of penalty. But one thing a domestic violence restraining order does do in a divorce proceeding is that if you are successful in getting a restraining order granted against your spouse, that spouse cannot ask the court for you to pay any type of alimony or spousal support. That is one advantage. Now, because of that advantage, however, a lot of people take advantage of the domestic violence restraining order process. They use it strictly as a strategic measure to gain an advantage in the divorce proceedings. So then later on, we're going to address what kind of evidence is needed to ensure that you're going to go ahead and get that restraining order granted. When it comes to evidence, just like every other case, the more evidence you have or the stronger evidence you have, the stronger likelihood it is that you're going to win in court. But when it comes to domestic violence restraining orders, it's almost nearly impossible to have surveillance running to capture the footage of your partner putting hands on you, or an audio recording of them threatening your life or threatening to use any type of weapon or bodily injury. It's almost near impossible. So what courts really do, they look at credibility of the witnesses. You, the other side. If there's third-party witnesses who might have heard certain things or seen certain things occur, text messages, emails, any type of communication that's written. Obviously, the more evidence you have, the stronger likelihood you have to getting that restraining order granted. And certainly having a seasoned family law attorney in your corner to fight for you will increase your chance in getting that restraining order granted. So the question is now, what should you do if you feel unsafe in your own home? The very first thing you should do is always contact the police. Creating some type of report with the police department, regardless if they just give you an incident report number or a full-on report, that shows the court that there's some type of imminent fear that you're experiencing, warranting you stepping into their courtroom and asking for that restraining order. Now, it's not a necessary step, but if you're actually in fear while you're living in your house, then it's very important to contact the authorities because they're going to get to you first before any family law attorney can file the restraining order documents on your behalf. The next thing to do is talk to a seasoned family law attorney, someone who has experience in the domestic violence restraining order realm, who understands what the court is looking for and how to portray the facts most favorable to you to ensure the success of your case. When we file a domestic violence restraining order, we move in on what's called an emergency basis or an ex parte. We don't give notice out 5 days out or 16 days out like a normal motion. Instead, we don't even have to give any notice. If you are in fear, if you give notice, they may retaliate. You can waive notice and proceed forward without them even knowing about it. You file the documents the same day and the court gives you an answer that same day. Usually in a DVRO, which is a domestic violence case, the court will grant what's called a temporary restraining order. This temporary restraining order is only valid for usually 21 days until you have your hearing, which is technically your trial. At that time, the other side is given notice. At that time, the other side is able to present their own evidence or be able to put on their own defense in order to ensure that the restraining order is not granted against them wrongfully. But that's also your opportunity to really bring in the evidence and convince the court that a domestic violence restraining order is warranted. In this video, we covered a lot of questions and we went into even specific detail. If this goes over your head or if you have further questions or like to even discuss your case in particular, we offer a free initial consultation. Feel free to give our office a call. We'll be happy to sit down with you and discuss your case in more detail.